The purpose of this session is to be very practical. I want to walk you through developing your own policy. So let me see a show of hands. How many already have a facility use policy, a policy regarding when and who can use your building? Raise your hand. Just a handful of us. Oh, there's several more popping up. Okay, good. About half of us maybe. Good. So you ought to incorporate everything that you already need in your policy. This is strictly what you would need to put in there to address this specific issue. Does that make sense? So it's not meant to, I give you a little bit of model language to include some other things like no smoking in the building or whatnot, but that's not my intent to leave that stuff out. It's just I don't want to without consulting with you directly, it's hard for a model to cover everything. All right. So here's the question. How to handle a request for marriage by a same-sex couple. And this question is not hypothetical, unfortunately. Since June, several congregations that are in the churches of Christ have been called up and asked by a same-sex couple, can we get married in your church building? Has anybody had that experience at their church yet? One, two different churches maybe? That experience can be a little unsettling. But I believe that there is some basic guidelines that you can follow to minimize your risk. You won't completely eliminate it. If they're trying to target your congregation for litigation, there is nothing short of compromising that you can do to avoid that lawsuit. But you can do some things to win the lawsuit. Does that make sense? But that said, I also want you to flip this thing on its head and look at this as an opportunity. And that's what the third session is going to be about, okay? An opportunity to minister to people in great need. Now, let's begin with, if that request was to come to you, what would be the process that you need to go through and understand? Step one, you need to understand your First Amendment rights under the U.S. Constitution. And this is something that I think a lot of people have taken for granted a long time in this country. And if you aren't abreast of Supreme Court jurisprudence, you may not realize that the First Amendment right has been diminished significantly since 1990. These are the next slide. There are 4 major upcoming issues for religious liberty in this country. And this is just a sampling. And this issue of whether or not churches can control the use of their building is just one of the 4. Whether or not they have to host a wedding, or whether or not a Christian entrepreneur has to serve a wedding with photography and bakery goods and that sort of thing. Well, the other issues that are out there is the Hobby Lobby case. As you know, Hobby Lobby won a very important case which recognized that corporations have religious rights just like individual citizens do. And that was a big win because that allowed Hobby Lobby to promote in their corporate policies religious beliefs and moral standards. And yet the Obama administration is still not backing down and refuses to extend that case to nonprofit organizations without litigation. Until the Supreme Court makes them, even though they had to let Hobby Lobby do it, they won't let Little Sisters of the Poor do it. And basically say, look, we don't want to be paying for insurance to allow our employees, we don't want to pay for their use of things regarding things that we believe are a violation of our moral beliefs. Well, that's one issue. And I think, at least I hope, that the Supreme Court will be consistent and extend the same rights and privileges to nonprofit corporations as it has for for-profit corporations. But then another issue is the military. The military chaplains, as you know, have been progressively watered down and limited in what they can do. They can hardly even pray in Jesus' name anymore. And as a result, their effectiveness in that position as a ministry is limited. But scarier than that is that there are efforts by the non-religious, even atheists, to commandeer the chaplain position and say, you have to let me be the chaplain just like a Christian. And as a result, you're completely undermining the ability for religious expression if you're in the military. Then the last example I'll give you is the adoption agencies, which we alluded to in the first session. And that is, we have a number of adoption agencies and orphanages in the Brotherhood. And there's a real risk, since they're so heavily regulated by the state and the feds, depending on the setup, that they will be forced to acknowledge or respect sexual orientation, gender identity issues, or allow a same-sex couple to adopt their children, or else lose their licensure. And that's a scary prospect that I believe will be on the horizon for many of these institutions. And I'm on the board of Rainbow Omega. I don't know if you're familiar with Rainbow Omega. They're in northeast Alabama, and they're a group home for 88 residents that are Down syndrome and other intellectual disabilities. And once their families get too old to take care of them, who's going to take care of my Down syndrome son? Well, we've got 250 acres. We've got occupational jobs. We work with the local Honda plant, and they can work for Honda doing certain tasks like any CRV made in North America. Everything in the glove compartment is organized by a resident of Rainbow Omega. And they're really proud of doing that work, and they work that assembly line as hard as anybody I've ever seen and do a great job. We have lots of nurseries with ferns and mums and poinsettias, whatever's in season, and we sell them all over, distribute them all over. And that's their income, and that's their sense of livelihood and a sense of job, a sense of purpose. And they get to work a job, and they've got a nice home to live in. They have homes all over the acreage that are nice homes with just 8 residents and a dorm mom kind of set up in there. And they live and very productive lives. Well, we are being heavily regulated, as you might imagine, because we have facilities all the way up to skilled nursing facilities. And so we have a lot of regulations, and most of our residents collect federal Social Security, Medicare, Medicaid. And so there's a lot of stipulations on accepting that money. And so we've been under pressure for the last couple of years to compromise on some things. For example, we were asked by the state of Alabama, and we had to go all the way to the lieutenant governor of the state of Alabama to sort of fight this off. We were being pressured and being told in these meetings at the University of Alabama by the professionals in this field that you need to be helping these mentally handicapped people, who are also physically disabled in many instances, be able to engage in sexual relations outside of marriage as part of their fulfillment and personal fulfillment. And then there needs to be a plan to help them date and have sexual relations, and even if you had to put them in position so they could have intercourse. I mean, that's the kind of advice we're getting from the so-called leading experts in the field today at one of the finest universities in the state of Alabama. That's really scary. And there's no acknowledgement whatsoever of our mission, our religious faith-based mission. That was almost something they're wanting us to jettison any they want to pay lip service to it at most. So I give you that example to say, look, there's a lot of religious liberty issues that we're going to be facing in the coming few years. But regarding this specific issue, your ability to use the building, or same-sex couples' ability to use your church building. Let me go to the next slide. The Supreme Court says, in their opinion, they say many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. Good news. So we're trying to understand what's your First Amendment right under the First Amendment according to the U.S. Supreme Court. And they're saying, if you believe it's wrong, we're not trying to disparage you. Next slide. You can, that first paragraph says, you may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. Next sentence, they can seek to teach the principles. Well, what's interesting is it never says you have the free exercise of religion. Never uses that language, which, by the way, is the language of the First Amendment. Instead, the Supreme Court only says you have the right to teach or advocate. That's talk, a good game. Not do, not act on your faith. You see it? Not free exercise. Just talk about it. So the dissent points this out. It says, it appears all but inevitable, this is what Justice Thomas wrote in his dissent, that civil marriage and religious marriage will come into conflict. But look at what Chief Justice Roberts says. The majority graciously suggests, and he's being sarcastic, that religious believers may continue to, quote, advocate and teach their views of marriage. The First Amendment guarantees, however, the freedom to exercise religion. Ominously, in other words, he's imputing bad intent. Ominously, that is not a word that the majority uses. So he's telling us, as churches, you ought to be worried. As Christians, you ought to be worried that they're not telling you have the right to free exercise of religion on this issue. You only have the right to teach and advocate. All right. And that's what he says in this further decision. And he points out specifically how a Christian college like OVU or Freed Hardeman would possibly have a problem. He says, when, for example, a religious college provides married student housing only to opposite-sex married couples, or a religious adoption agency declines to place children with same-sex married couples, the Solicitor General for the United States candidly acknowledged that the tax exemptions of those institutions would be in question if they opposed same-sex marriage. You lose your tax-exempt status, that's a problem. Then your revenue that you make is taxable. Plus, the people that make donations to you can't get the tax write-off. Charitable deduction. All right, you get the point. So he says, unfortunately, people of faith can take no comfort in the treatment that they receive from the majority today. So, that's your First Amendment rights. So what's your best defense? Unfortunately, it is not the First Amendment. It's a little-known law called RFRA, R-F-R-A, the Religious Freedom Restoration Act. That's the law you're going to have to learn to use in the states, the 23 states where it's been passed. If it hasn't been passed, you need to be encouraging your state legislature to pass it. Now, why is RFRA so more valuable than the First Amendment to the U.S. Constitution? Because the Supreme Court in 1990, in what is known affectionately as the Peyote case, the Employment Division v. Smith case, held that a religious group, they happen to be Indians, did not have the constitutional right under the First Amendment to engage in their religious ceremony because it involved drugs, peyote, and they were getting high during their religious service. And so they said, no, this is part of our religion. And the Supreme Court said, no, the drug laws are a general law that apply to everybody. And as long as it's a general law that applies to everybody, they don't have to give a good reason for why they are infringing on your religious rights. Well, when it comes to drugs, just so you know to drugs, I'm not for drugs, right? And I'm thinking, that makes pretty good reasoning. But what you don't realize, just like I saw with the Griswold case, started out innocent enough, just let married people decide what they want to do in their bedroom, and you now end up killing millions of babies, right? Same problem here. In the Employment Division v. Smith case, what the Supreme Court was saying is that they no longer were going to force the state to give a really compelling state interest, a really good reason for infringing on religious rights in this country, as long as they make the law apply to everybody equally. This whole equal protection thing, that's your problem, okay? I mean, the way the Equal Protection Clause is used by the Supreme Court has been a nightmare. And it's the premium they place on almost every situation. Now, what that means is that once they abandon the compelling interest test, which before, if that was in place, you could never have your religious rights taken away, because there was hardly anything that the state could do to show they had a compelling state interest in infringing on your religious rights. There was never a good enough reason to satisfy the courts to uphold the law, so the law always got struck down if it negatively impacted a religion. You with me? But now, without that test, they can pass whatever law they want as long as they apply it to everybody. Well, think about the possibilities under that scenario. Why not pass a law that says nobody is allowed to get together on the first day of the week in groups more than 50? It's a general law. Now, obviously, that have an impact on religion, but we don't care about that anymore. We don't have to meet the compelling interest test. As long as it's generally applicable to everybody, that would be constitutional in the First Amendment. You see the problem? They can negatively impact religion because everybody else wants to sleep in on Sundays. They don't care about getting together, right? Unless you're religious, why would you get out of bed on Sunday morning? Go fishing, maybe. But only 50 people can't fit in the boat, so that's not going to be a problem. See the problem? And so what's happened is that the federal Congress in 1993 saw this problem and passed a law, not a constitutional amendment, a law that reverses the Supreme Court case. But the Supreme Court then said, no, that will only help you for a federal law. You cannot govern state laws. So if states want to reverse this for their laws, then they'd have to pass their own RFRA. And 23 states have done so. Okay? So now, as a matter of state law, a state cannot pass a law, even if it's generally applicable to everybody, if it's going to substantially burden religious freedom without giving a compelling state interest, a really compelling state reason for doing it. And very few reasons are enough. If you can show it's going to result in genocide, that's enough. If you can show it's a national security risk, a real national security risk, not the green light, yellow light stuff that's going on since 2001, that's enough. But generally speaking, compelling state interest is a deal breaker, and it usually results in the law being struck down. So we have federal RFRA and state RFRA laws. And here's how they work. They apply to individuals and to entities like a company, a closely held company like Hobby Lobby, or to a church. Here's what has to happen now under RFRA. If the city, if this city was to pass a law saying you have to let same-sex couples get married in your town, in your church buildings, every public building in town that's open to the public at any time has to let same-sex couples get married there too. If they do that, then you would have to raise the RFRA defense. And here's what you'd have to show. First, you have to show that you have a sincerely held religious belief. Can't take that for granted now. There's a lot of denominations that ain't got no problem with homosexuality. They act like it's not even in the book. And they would even further, you can read a very popular evangelical magazine, I think it was just this summer, had a whole issue on this question. And it was Christianity Today, CT. You heard of this periodical? It's not a brotherhood publication. It's just a general faith-based publication. And they asked the question, and if you read the article, it had 3 authors giving 3 different perspectives. And some said, absolutely not, you shouldn't, participate in a same-sex wedding. The other one said, oh yeah, you should, because that's the best way to minister to them, and is to go ahead and participate in that so you can befriend them. And then there was one in the middle that sort of split the baby. And there was no editorial that said which opinion is better than the other, because they're trying to cover the whole range, even in evangelical circles, of the appropriate response. You with me? And so you're going to have to, as a congregation, be able to say in a court of law, we have a sincerely held religious belief that believes that homosexuality is wrong, and that furthermore, facilitating or promoting homosexuality, even under the guise of marriage, is wrong. You got to believe that. You got to be able to say in a court of law that our congregation believes that. Well, if you're not teaching it, I guarantee you, people aren't just going to be able to articulate that. Okay? So you're going to have to, step one, have a conviction. If as a congregation you don't have a conviction on this issue, you're dead in the water, and you might as well go ahead and roll over. So that's a big step. So as an eldership, y'all got to pray and study the Bible and open it up for yourself, and like the Bereans would, and say, look, is what Matt's been saying that it's wrong to not only engage in homosexual sex, but to help promote that? Is both those actually wrong? And if you have that conviction, and you can testify to that in a court of law as a church, not just as an individual, then you can claim that they are infringing on your religious freedom, and you have a defense under RFRA to not have to go along with that law. So, first step, have a sincerely held religious belief. Second step, has to be substantially burdened. So you have to have a sincerely held religious belief, and that's why you need to have some bylaws or a statement of faith or something that puts it in writing before you get sued, so that you can say, oh no, we've believed that for a long time. Back in October of 2015, we actually put it down in writing, but we even taught it for generations. You see it with me? So that's why we're going to talk about a policy. And then you have to show that substantially burdened, because they're saying you have to do what you say you can't do. And then the RFRA law says they have to articulate, in order for them to be able to substantially burden your sincerely held religious belief, the government has to articulate a compelling government interest. Furthermore, even if they said, hey, if we don't do this, it's going to result in a riot, it's going to kill 10,000 people in this town. Well, that'd be a pretty good compelling reason to save 10,000 lives, right? Even if that's true, the next question will be, under this statute, was the law narrowly tailored? If you're the only church in town and there are 15 other places they could have gotten married, and the only social policy was to make sure same-sex couples could get married so that they wouldn't riot the streets and kill 10,000 people. You with me? And there's plenty of other places they can get married because a bunch of denominations will accept them, the courthouse is always open, etc. Then why not narrowly tailor the law to only exclude the churches that have a sincerely held religious belief against it? You with me? And by not narrowly tailoring it, they run afoul of RFRA, so they lose. So they first have to have a compelling interest, and they ain't going to have a compelling interest. There's no evidence 10,000 people are going to die if you don't do this, right? But even if they did, they'd have to show why they didn't narrowly tailor it and exclude the churches that don't want to do it, assuming there are plenty of others. To still illustrate that, let me give you a better example. This summer, that clerk in Kentucky that didn't want to have to marry same-sex couples, license them, issue the license, if she had just been a clerk and not the elected official over those offices, see, if she was just one of 10 clerks in that office, would it not have been easy enough to narrowly tailor the rule to say, look, let one of the other clerks issue the paperwork? And the ones that have a conscientious objection or sincerely held religious belief that they can't do it, let them not have to do it. And it's just to accommodate their religion by letting other coworkers do it, because there are 10 people that can do it, and there's always somebody else on duty that doesn't have a problem with doing it, so why should I have to do it? Does that make sense? That's how you would narrowly tailor the policy. Well, in the Kentucky woman's situation, the problem was a little more complicated than that, because she had her signature on every single license. And she had a problem with endorsing her signature on a same-sex couple license. And every one of them had her signature. So there was nobody else's signature except hers. So what would the state of Kentucky have to do to accommodate her would be to pass a law that says there's a couple of people that can sign it. And if this guy doesn't have a problem with signing them, he would sign them, and then she would, if that makes sense. So I'm just trying to give you, that's involving a state agency, a government situation, so it doesn't exactly parallel, but I'm trying to give you an example of the kinds of ways that they would have to narrowly tailor the law or the rule in order to comply with RFRA. And that third requirement, that it be the least restrictive means requirement, go back to the previous slide. That third requirement, that the law must be the least restrictive means, is pretty much the same thing as saying it has to be narrowly tailored. All right, now we can go to that next slide. So what kind of compelling interest would be enough? Like I said, to save the lives of multiple people, national security, and not violating explicit constitutional protections. The problem is that they're writing into the Constitution these new fundamental rights, and that's going to be the battlefield. Does the fundamental right to marry whoever you want, does that constitute an explicit constitutional protection or not? Now that it's been articulated by the Supreme Court, they just wrote it in. That's yet to be decided. All right. So, but remember, RFRA is not as good as the First Amendment because the next Congress can repeal it. The next legislature can repeal it and take it off the books as if it never existed. So we really need to get back to the next president's going to have a chance to appoint at least 2 justices, probably 3 in the next 8 years. And that's our best opportunity to get this case revisited or to get a First Amendment case revisited and have the old compelling state interest standard put back in place constitutionally as opposed to statutorily. All right, so that leads us to step 3. Once you understand your First Amendment rights are limited and that your best defense is RFRA, and you know how that works, now you're ready to write your policy to minimize your risk of being sued, or if you get sued, maximizing your ability to defend yourself under RFRA. Does everybody understand what we're doing? Look at it. Take a look at your first handout, the one that says Sample Facility Use Policy. And let's walk through it together. The first thing that you want to do is to make sure you're minimizing the risk that anybody could sue you. And right now, as a church, you have the right to teach and advocate whatever you want, so long as, and you have the right to do whatever you want religiously in this building. But the key is it has to be religious. You don't have the right to set up a public restaurant in the foyer and say, no blacks allowed. You don't have the right to set up a barber shop in the back hall here and say, no, some protected class allowed. Because you're providing services to the public and you're deemed a place of public accommodation under non-discrimination laws. Right now, the non-discrimination laws, the federal law, only prohibits discrimination on the basis of race, sex, color, age, national origin, religion, right? It doesn't protect discrimination on the basis of sexual orientation. It doesn't prohibit discrimination on the basis of sexual orientation yet, except for federal contractors. It does already under executive order that Obama signed. I believe that they will soon extend that list to include sexual orientation, like many states and municipalities already have. And most of your companies, if you work for a big company that's in multiple states, has already adopted that language in their EEO policies because it's too hard to do business not discriminating in one state and discriminating in another state. So they just said, half the states are already saying you can't discriminate on the basis of sexual orientation, so we'll just across the board, even in a state that's a conservative state like Tennessee or Alabama that doesn't prohibit discrimination on the basis of sexual orientation yet, and the feds haven't yet, they still hold to that policy. So I believe it's a matter of time before every state it will be illegal to discriminate if you're a place of public accommodation. And if that's going to be true, then you've got to position your church best you can to avoid falling into the definition of a place of public accommodation. What isn't a place of public accommodation? A private club, a private country club. They can still discriminate. It ain't popular, and people will blackball their country club if they do, so not a lot of them do it anymore. But, the Masters and others did it for years, right? The Masters, for years would discriminate and not allow women in their club. Well, that's gender discrimination. That violates federal law. Well, not so if it's not a place of public accommodation. You see how important it is to be a place of public accommodation. That's why it's such a defining issue. So how do you avoid a church that is trying to be a light on a hill to a community, trying to have outreach and ministries to the community, trying to save as many lost souls as it can? How does it avoid being labeled a place of public accommodation? I don't have the answers until they come out with a rule on what the definition is, then we can really craft. But right now, my position is that regardless of how they define the place of public accommodation, if you are doing what is inherently religious activity, you'll either not be a place of public accommodation for that purpose, or they'll give you a religious exemption. That's what I'm counting on. Is either you're not doing the kind of stuff that a community center is doing, or it is, which would be non-religious secular stuff, or it's religious stuff that you're doing, and it's open to the public, but it's religious stuff, and you get a religious exemption to be able to do that stuff. Okay? So under that premise, I believe the best strategy, and I've consulted with a number of lawyers on this, and this is the best one that we've been able to come up with. And just for full disclosure, this came from some personal responsibility that I felt at the law school to be a resource to the church, but in particular to respond to the fact that we were training lawyers at that law school who were not Christians, who then used the license that they received to practice law to represent gay couples in federal court. One of those cases went all the way to the 11th Circuit. And the federal judge that decided the case at the district court level happened to have a son who was gay and rolled over and declared same-sex marriage valid. And basically, my law students were responsible for winning a case for the other side. So it's like we taught them how to shoot a gun, and then they turned it on us and shot us. And so I felt a lot of personal responsibility regarding that. And so we actually had faculty involved, law school faculty, involved in writing the briefs, ghostwriting the briefs for the Attorney General, for the State Attorney General's office and the Governor's office, trying to fight these federal lawsuits. And we weren't successful. As you know, the Sixth Circuit was the only circuit that actually decided it the right way. And then when the circuit split, cases went up to the Supreme Court held what it held and ruled the wrong way and upheld same-sex marriages. So, full disclosure, this is an issue we've been working for several years, even before the decision, and so we've given it quite a bit of thought. And the best strategy that I can recommend to the church is that you try to focus on religious ministry work. Use your building for religious purposes only. Now, I didn't say liturgical purposes only. I didn't say just your worship service. But it needs to be religious. And do not allow anybody to use the building for non-religious purposes, because then it looks more like a community center engaging in secular work. And if it's that, then it's a place of public accommodation. And when that law gets passed, boom, you're covered. There's no religious exemption because it wasn't religious activity to begin with. And so if you'll let a non-religious activity to take place for one group, why not for the same-sex couple groups? Why not? If you let the homeowner association meet in your building with no religious component whatsoever to that work, directly, expressly, why not let the local lesbian gay chapter meet for their monthly meetings in your building? You see it? What's the difference? If it's not a religious thing, it's not a ministry work, why not? So, that seems limiting, and I know it is limiting, given the fact that we've got ball fields and gymnasiums and we've got Girl Scouts and Boy Scouts meeting in our buildings, and we've got it being used for voting precincts, and we've got it being used for AA meetings and all kinds of really good works. My challenge to you is to ask yourself, is this a work of the church? Or is this something that you're just allowing them free rent or free space to engage in a completely secular work? And there's two different answers that you can give. If it's not, if it's right now has no religious nature. The first answer is make it religious. You got an AA meeting in your church building? They can have those meetings and either approach it from a Christian view approach or a completely secular, non-theological approach. Are they praying? Are they being led by one of your ministers? Or is the minister allowed to have an opening prayer and really encourage them and say, we're so glad to have you here, and then let them do what they want to do? I mean, does it have a religious component or not? Boy Scouts, or let's get to something completely secular. Letting the Little League ball team in town use your yard to have practice. Well, that may or may not be a part of your ministry. But if you want to make it clear, because I understand how you could make the argument that indirectly you're trying to build goodwill and a good reputation in the community, so you just let them, no strings attached, no harassment, no proselytizing, use your yard because you're trying to be a good neighbor. And I understand that, but I'm telling you, I can't defend that as well as if you tell me or you could testify to the judge, you don't understand, Your Honor, that is a very important ministry, because those young children that are there and the coaches allow us, they understand that they're going to use our field, that when our minister is there, he will bring them all to the center of the mound and have a prayer with them during the middle of practice, and just tell them how much we appreciate them having them, and invite them to church or invite them to VBS or whatever. And so I would much rather defend that as a religious work than I would, there's no Christians overseeing the work, there's never any religious aspect to it, they're just using our space. You see it? Even though I could defend that, I don't want to have to. So try to turn everything into a religious ministry, overtly, some kind of religious ministry. And you don't have to shove it in their face, and there's only so much you can do, because it's a process to get people to be receptive to the gospel. But you need to be looking for those opportunities to make it more spiritually active in their component to it. The second thing, so you can stop doing completely secular stuff, just stop doing it, or you can convert it to make it religious. Or if there's some things that you just can't convert, there's no way, for example, voting precinct. The voting precinct issue is a popular one, because if you're the big space in town, it's a good place for voting. You're trying to be a good neighbor and help out the city, so they don't have to build another building just for voting. And it lets people know where the building is, right? And so I can explain why a church would want to do it, and because they believe it'll increase the visibility of the church so that they can do good ministry. But if you know that they're not going to let you do any proselytizing, you got to take all the pamphlets out of the foyer, you can't make it religious, because they're worried about separation of church and state issues, then what? Well, you can do one or two things, depending on how risk averse you are. You can either, for every no, create a yes. And so for that, let's say the homeowners association wants to meet here, or the voting precinct, but the homeowners association is even better. And they say, we understand you, but we really wouldn't feel comfortable with you saying a prayer at the beginning of our homeowner association meeting, because we got a lot of Jews in the neighborhood, we got a lot of Buddhists, we just don't want that. You know what you can do? You can say, well, I'm sorry, but this building's reserved for ministry purposes. And if you're not really interested in any kind of ministry, then we really can't use the building. You can't use the building. Or you can roll the dice and say, you know, I know what the lawyers told me, but I've got 10 things in this column for why this building is really reserved just for religious purposes. And only one or two exceptions, like the voting precinct. And that there's a balancing test that the judge is going to do, and on balance, I think we're okay. And you can be a little risk averse. Be a little less risk averse and take that risk. I would rather defend a church that everything that's being done in the building has a explicit, direct religious or ministry purpose. I'd much rather defend that. But if there's one or two things that you believe you would just really harm your reputation in the community, harm your goodwill that you've built up over the years by stopping, then I would recommend that you make that judgment call. And if you have to stop it, I recommend that you create another opportunity targeted for that group. So like, let's say with a homeowner association, well, if you don't feel comfortable, we understand that, but you got to understand where we're coming from. We can't open up our building for that. But then I would turn around the very next week and organize a campaign to take some kind of care packages or some kind of gifts, fresh bread or cookies to every neighbor in that neighborhood, and to make up for the fact that you couldn't let them use the building. Does that make sense? For every group that you have to say no to because there's no religious purpose they're willing to let you add to that event, you still need to find a way to minister to that target group in an appropriate way. Does that make sense? So that you either say no, make it religious, or say no and add a yes to it. Add a yes to another event targeting that same group of people. So that's my advice on that. But the bottom line is the facility use policy that you have in front of you has one paragraph at the beginning that basically says the church facility will be used only for religious and ministry purposes. And that's my recommendation. Next slide gives you some language. Go to the next slide. This is the second thing. Limit the use of the building to members of the church. This is one that I've really vacillated on quite a bit. And so I've included an alternative. Alternatively, you may choose to allow limited use for certain purposes to non-members, as long as they're not wanting to do or advocate something that's completely inconsistent with what your church teaches, okay? Why do I have that? I've been told by several congregations that they're going to take any chances, and they're only going to let members of the church get married in their building. Really? Really? Not really. What are the chances that both the bride and the groom are going to be members of the church? First of all, how many people get married out of your youth group? Big fat zero, right? Second of all, well, maybe one or two exceptions. Love to hear the story. Second of all, when do they get married? Before or after they leave home? Average age in Tennessee is 24, 25. National average is getting up like 27, 28. They done left home. So the bride and the groom are adults, and they may not be living in the same town, much less going to the same church. But when it's time to get married, where does the bride tend to go? Back to their mom and dad's church to get married. Right? So neither one of them are going to be members. So if you're going to limit it to the members, what you mean to say is we limit the use of the building to events which are sponsored by or directly connected to at least one member, or something like that. But in reality, I think it's a hard rule to follow. And the only thing worse than not having a rule is having a rule that you don't follow consistently. Once you start being inconsistent, you're dead in the water. That's called pretext. And you will lose the case as soon as they can show that you made an exception for this family or an exception for that person, but you won't make the exception for the gay couples because you're a bigot homophobe. That's your reason. You're dead. You lose. You have to, whatever rule you adopt, you have to understand it and you have to consistently follow it. Otherwise, don't even bother going there. So, what I'm suggesting is the language in paragraph 2 of the sample that says the church facilities are not generally open to the public. See that word generally? Not generally open to the public. I'm trying to hedge the bet and say we're not just a civic center. We're more like a private club. But, and nobody's allowed to use this building without approval. Didn't say membership, said without approval of the elders. You see the difference? So I've hedged the bet a little bit with this language to make it something I think you can operate with. And that the facilities are reserved for people that agree to abide by all the rules. And the rules will specifically include no alcohol, no smoking, no doing anything we don't approve of, including joining same-sex couples in marriage. Okay? So that's the way I've worded that. So let me stop there and ask for some questions or input on either of these, because these are the two most important provisions. Either the provision of limiting your building to religious ministry purposes, or the provision of limiting it to individuals that have the express approval of the elders and agree to abide by the rules. Any questions about either one of those? Any scenarios that you're wondering about which way does that cut? None? Great. All right.
You can have a member that's in the Boy Scout troop who was there, although he's a member of the local congregation, that we consider to remember the religious.
Yeah, I mean, I think Boy Scout groups can be led by the scout leader to include prayers and religious principles and discussions on spiritual things, and not just secular stuff. Yeah, and the problem there is you get an affiliation with the Boy Scouts of America, which is now requiring you to, basically compromise on that issue and agree to compromise on that issue. Well, I mean, what are religious purposes? Don't they extend to all of the acts of worship plus benevolence and fellowship? And so I would say that a birthday party celebrating, a lady's 90th birthday in the church is fellowship, Christian fellowship, right? Benevolence is very broad too. So I'm not trying to limit y'all to that much. I'm just trying to say, remember, you're going to have to testify on the stand that this is a religious ministry. And you got to explain it and not just assume it. And so if it ain't overt, make it overt so that you can explain it better. Yeah.
So this is in the realm of public service, but it also makes our facility appear to be usable by the community. Things that relate to the Red Cross, like blood drives and emergency shelter.
That's right. Yeah, these are community outreach efforts, letting the blood mobile come to your church and set up and do. Those are acts, I believe, those are acts of direct service and benevolence, right? And so I think that emergency disaster relief is another one that comes up a lot. Providing blood, which is a real need, is another one. Collecting money and sending it to, Haiti or wherever is another. That kind of thing, even if it's not a specific opportunity on that occasion to proselytize, to evangelize, it is, I think, religious, a ministry for you to collect funds, for example, and to take care of the brethren first that just got hit by a tornado. But then the scripture goes on to say, to all men, right? To help all men. So I believe that we can engage in those kind of activities and it be a religious ministry, even though it doesn't have a teaching component to it. But I think those disaster relief efforts and that sort of thing can't overshadow the work of the church, because I think it would undermine your argument if you do it too much, or if you build an entire thing just to do that all the time. And then you say, no, I can't use. So the question is also with these ministries, remember, it'll be context specific. Are you discriminating against homosexuals in that ministry? And if so, that ministry is not going to be anything more than a list of things that are going to be put in 2 columns, religious, community center. And if you only have a couple things in the community center, I'm not worried about it. But if you have a bunch of stuff in the community center, you've got a soup kitchen, you've got all this stuff that a secular group could do, and very little religious, then you're probably a place of public accommodation. Okay? Yes, sir?
Yeah, we have, it's not our main.
Right. And a lot of churches have benevolence pantries where you can, store up goods that are open to the public. And I believe that's benevolence. I don't see that outside the parameters of religious ministry.
Yeah, we were wondering. I know it's in reference to the concern of some of our how can we word that?
Yeah, I asked Earl how many churches here would not have an eldership. How many others are working with a congregation that does not have an eldership right now? Several. It needs to be worded to reflect the organizational authority within your organization. And so generally that's a men's business meeting. You probably had to deal with that if you were incorporated when you set up your articles of incorporation and your bylaws. So follow that same model to make those adjustments. But yeah, this language assumes the authority of an eldership because I wanted to give as maximum discretion to them as possible so that we could defend any decision they made, basically, for that congregation. And not get in disputes in the court over whether or not they were interpreting the verse right or not, for example. That don't matter. Their interpretation is the end of the discussion. And the courts have no right to pierce that at all. And I can defend that. I've handled a couple of religious discrimination cases where we were able to clearly keep the court out of the business of second-guessing an eldership's interpretation of Scripture. But you've got to make clear that you believe for that congregation the elders have the authority to interpret the Scripture and make those decisions. Yes, sir. Then I think that'd be a great ministry opportunity. Which preacher would not love to have every member of the neighborhood in your building once a month or so and get an opportunity to speak to them about spiritual things? Pray for them and encourage them to come to services. That'd be awesome. If you can make it religious, then it's religious and you're fine. If you can add that component to anything you got going on right now, then I think you can defend it on the strongest ground that it's not something that the state or the city or a community center could do. Because they got separation of church and state. They're not going to be engaging in those kind of activities unless they're breaking the law. Oh, so as long as the gay group agreed to let you do a Devo and talk to them about spiritual things, should you let them come in? I think that's a good question we got to talk about this afternoon, about how to minister to people that are struggling with same-sex attraction. And is there a difference between people that are struggling and people that are closed-minded and believe what they're doing is just as valid and intolerant of you and your religious beliefs? It's a good discussion. Let's save that one for this afternoon. Yes, sir. Yes. Page 2 of the bylaws, paragraph 2. Yeah, there is some language for the men's business meeting that this is Gary Macy's document, added. So make a note of that. That might be very helpful for you if you're in that situation. Thank you for pointing that out. These bylaws are fresh off the print. I talked to him the evening before I got on the plane to come here, and he rewrote those for us. So you're the first group to get them. Yes, sir. Yeah, sponsorship, you're going to lose control. So you'll have to make your judgment call and sponsor something that you agree with and stop sponsoring it when you no longer agree with what they're doing, right? But the other question that I thought you were going to ask was, what about other properties like church camps and buildings and facilities or land or whatever that you have elsewhere? Because those are where they are targeting a lot of lawsuits, because if you have a beautiful campground, the LGBT group may want to have a meeting there, and if you let other groups have a retreat there, why not them? Or if you have a beautiful, little chapel on a hill for a wedding, that's going to be a target. So don't just think your facility, think about any facilities that you own as potential targets for this. But if you're just sponsoring, then that sponsorship should only happen so long as they're doing things that you can sponsor. Once they don't, then you're going to have to stop sponsoring, because you won't be able to control it because it's part of another organization. Yes, sir. Yes, I do. Everybody needs to hear that question. He said, do you suggest that all churches consider incorporating? And I do, for this reason. I think there's a lot of misunderstanding. You do not give the government any more power over you by being incorporated, or another case in point, taking advantage of the tax-exempt status. They're going to treat a church as tax-exempt whether you officially take advantage of it or not. And they're going to regulate you accordingly. Because you're a church, you're already regulated by the IRS. So you're not giving them any more power over you by taking advantage of it. And likewise, the incorporation statute doesn't give the state, by virtue of the fact that you're in the state, they have the ability to regulate you. They control that exit sign. They control reasonable accommodations for people with disabilities if you're going to add on to this building. They control you no matter whether you incorporate or not, okay? The question for incorporation is very simple. Do you want to tell the public at large that if they sue you, they can take your church building and they can take your church bank account, but they can't take the elders' personal houses and the members' personal bank accounts? That's it. That's it. That's the only reason why you incorporate, is to let the world know that you do not want them to take your personal houses, that you want to limit your liability to the assets of the church. That's it. And if you do not publicly declare that by filing $50, go to the courthouse, probate court, wherever you go, and let them scan a one-page document saying the church is now Church of Christ, Inc., for purposes only of making this declaration, then you don't have limited liability. You're just an association. And that means each and every member of that association, especially the leaders, are personally liable if somebody slips and falls in that hallway on Sunday morning and breaks a hip and incurs $300,000 worth of medical bills. So whose house do you want to auction off first? That's it. It's all about limiting your liability, and the courts say unless you notoriously limit your liability by putting it on file with the state, that's called incorporating, then you're not going to be covered by limited liability. And it's a little bit more than that, because once you put that piece of paper with the state, then you have to follow the corporate formalities. You have to have an annual business meeting. You have to do a few things, file a little paperwork every year. But that's basically to buy insurance. So question, does your church buy insurance? Well, why not pick up the free insurance policy called limited liability by incorporating? That's all you're doing. You're not giving them any authority. You're not giving them any more power over you than they already have. So yes, I believe incorporation is a wise thing to do. Yes, sir. If Freed Hardeman was doing it, it wouldn't be a problem. If OVU is doing it, it could be really problematic. Sorry, I had to take a stab at it. No, that's not a problem at all. Because why? I mean, they are working with you in a ministry work. Most faculty at a Christian school, well, not most, many faculty at a Christian school actually have ministerial status. And I believe the work they're doing is not just a secular work. It's to educate in a particular vocation with a Christian worldview and use that as an opportunity to convert souls or to raise up the leaders of the church and prepare them to do roles like what you all are filling now. So I definitely believe that's a ministry work. Yes, sir. Yep. Great question. Let's move on, because I hold that question. Let's get to it as quickly as we can, because I know it's time to eat lunch. The next step, go one more. Explain the procedures for how to obtain permission. So your policy, go back to the policy. We're going to get to his question as quickly as we can. And his question was, how do you if somebody's going to get sued eventually, so what then? Or how do you prepare for that directly, specifically? All right, so the next question is guidelines and requirements and procedures, right? So you need to make it clear, here's how you can get authority to use the building. And the elders get to make that final decision, no ifs, ands, or buts. So that's the second half of the first page under obtaining permission. The first half is who can get it. The second half is who they have to get that permission from, the elders. Or if you don't have elders, you'd add business meeting. All right? Go to the next paragraph. Next one. So then, next section is called facility usage fee, right? Everybody see that? You have to make a decision. So the third thing you've got to decide is, what do you want to charge to use your building? Now, I don't have time to explain it all. Let me just sum it up for you. Under the IRS code, if your building is not yet paid off, you are jeopardizing your tax-exempt status if you charge a fee for people to use your building for any reason. Is that clear enough? If you have your building paid off, then you can charge a fee, but you will run the risk of looking more like a place of public accommodation making money for profit than a church that's not a place of public accommodation unless you charge less than fair market value. So figure out what it costs in town to rent a similar space and then substantially discount that price and just cover the cleanup fee or whatever it is you need to charge, right? Make sure it's less than what anybody else in town would charge if they're not religious. Does that make sense? But if your building's not paid off, do not get in the fee game at all. It'll jeopardize your tax-exempt status. That's that. Next slide. Keep going. Those are those two languages, and they're here on this document. Make clear that under no circumstances can anybody, member or non-member, use this building for any inappropriate purposes. And you need to give some clear, concrete examples. Some of the policies that you'll find online on this issue are so generic, so vague, I don't know if they're trying to be politically correct or what, that you can't tell who can do what in the church building. You got to make it clear. The courts will not enforce a vague, ambiguous provision. And so you need to make it clear if you do not want alcohol or if you don't want a wedding of a same-sex couple being done in your building. All right, go to the next one. That's some sample language. Go to the next one. Specify any insurance and indemnity requirements. This goes to his question. If you'll look at page 3, I guess we're on, insurance and indemnity, this provision is only if you do not, as a church, feel like you have adequate coverage already. You may want to require people that are going to bring a bunch more people that are not members into your building and create some additional risk that you don't think you may not quite have enough insurance to cover. You may want to require, as a condition of them renting out your building or using your building, to carry an insurance policy, an extra insurance policy. That's fine. It's a lot of trouble. So I don't think you want to do it in every case, but it's up to you. My advice is you need to make sure you've got adequate insurance in any event, because they may or may not do it. You may forget to make them do it. They may say they did it and didn't do it. Lots of things could happen. You need to have minimum insurance for yourselves. Right now, best practice, even though I recognize the average Church of Christ has fewer than 100 members, is $1 million of CGL, commercial general liability insurance, with an aggregate of up to $2 million. So $1 million per incident, $2 million aggregate. So $1 million/$2 million CGL policy, you need to have one. They aren't that much, a few $100s a year, well worth the investment, just in case, some member slips and falls or somebody brings a suit. In addition to that, go to the next slide. I think it's there. Let's see what we've got here. Go to the next slide, see what we've got. No, come back. So in addition to that, let me add a couple of suggestions to you. I don't know where it's at, but it's somewhere in the slides. On insurance, there are 2 riders that you ought to look at. Number 1, once you got, how many people have got a general liability policy, $1 million general liability policy? Most of us do. Good. Number 1, immediately Monday, what's today? Yeah, Monday. Call your insurance up, call your agent up, and say, I just want to make sure if somebody was to sue us because we refused to let them use their building because they were gay, our building because they were gay, would you provide coverage for us? Ask them. Some will say yes, some will say no, some are saying no. You need to have a policy that says yes. I'm not endorsing a particular policy, but I will tell you that I have confirmed that Brotherhood Mutual does say yes to that question. They, in fact, are marketing it and building it as a special rider that they're not charging you for, just so you know you got it. Fine. I think most of them are going to say yes. Make sure your policy, number 2, includes cost of defense. It's not enough just to pay the judgment. Nobody goes to trial. This stuff always gets settled. Well, nobody except me goes to trial. FedEx taught me just go take things to trial. And we just stopped settling. And we actually had to try cases. Part of the reason why I went to work for them, because I was tired of just settling cases. I wanted to actually go in the courtroom and be Matlock, right? And so I never got to do that for these other companies. They're always settling. Well, FedEx actually tries everything. I mean, after a de minimis amount of settlement, if it won't settle, they try them. Well, you really need to know whether or not there's a lawyer that's being paid for, because even if you win the case, if you had to pay legal fees, you're talking $60,000 or more to defend that case. So you lost if you have to pay that kind of money, right? So I encourage you to check your insurance policy for the amount, $1 million/$2 million at least, and $2 million for individual instances might not be a bad idea until the Supreme Court works out a few more details on what is and isn't legal. Secondly, make sure your insurance policy covers costs of defense. Third, make sure it specifically covers same-sex wedding refusals, religious freedom issues in general, ordinances, anything like that. And then the last thing is many of us use volunteers to do church work, and they use their own vehicles. And what I found is a lot of people in Alabama, like 40+%, are not insured. They're running around uninsured motorists. I don't know what it's like up here, but that is scary. And as a church, you can get a rider on your car insurance, your vehicle insurance policy, to cover the volunteers' personal vehicles when they're using it to do church work. It's a special rider you can request. And if you've got a little more money to invest in some insurance, and you're looking for some smart places to spend money, that would be a good endorsement. That'd be a good rider to add. And then one more thing. I know I said that was the last one, but one more I just remembered. It's called EPL insurance. And this is for employment practices liability. If you refuse to hire a secretary or a janitor because they're gay, right, you're going to need to defend that potentially in a court of law. And I think it's very important that you have a job description that makes clear what the religious purpose of that role is and why it wouldn't be appropriate for somebody that's practicing sin openly like that, habitually and in rebellious way, to be in that role. But you need to have a job description that explains the religious purpose of that job, and then when you make those judgment calls and refuse to hire a church secretary that's a lesbian practicing homosexual, then you need to understand that your insurance company probably won't cover it when she sues you unless you have EPL insurance. And EPL insurance has gotten much cheaper now, so it's affordable. All right, so those are some specific suggestions on how to handle or pay for potential lawsuits.